Welcome back to CME 452's online edition, our weekly video PowerPoint video update. This will be our final one. Recall that next week is reserved for you to work on your final presentations, in which you can choose one or up to three cases that you feel are especially pertinent to your own career development, and do an extended presentation that's modeled sort of on the one that you've done, but just um, go a little bit more into depth about the importance of it and the relevance of your case or cases to your own career development. Okay, so this week we'll be dealing with some topics that are specific to the music industry, such as agents and music publishing, as well as another couple of topics that are a little bit more broadly related, not just to the music industry, but to the entertainment industry itself. So, looking at, we'll start with personal managers, also known as talent managers or artist managers, depending um, on your field. Um, they're largely synonymous terms, so it doesn't really matter. Um, in any case, the 15 to 20% rule applies as a commission rule of thumb for how much these, what the payment for artist managers usually is, and this depends on the clout. So if you've got a little bit more clout as a manager, then you'll be able to push that up. If, however, you're new and your artist has the name brand already established, then it'll be 15% or below. There are some situations, exceptions to the rule, like Lou Pearlman, who is a famous manager for a lot of boy bands. He sometimes would get, because he had orchestrated putting them together and was managing every aspect of their career, he was known for getting 35, 45, even as much as 50% of everything that these guys did. So this would be an example of a full management deal where both the business and the creative aspects of the artist's endeavors are controlled by that manager. In any case, the managers, basically what they're responsible for is putting together a development team. And so in the music business, this usually starts with an agent to secure employment, and then may go to a publicist, a record company, a music publisher, even a choreographer, and that type of thing. And so they're responsible for putting together this that would be the professional development team, and then to kind of manage and orchestrate how that team does its job. In terms of how these responsibilities turn up in a management contract, you're talking about a clause that is called the appointment of authority clause, and this will be it's not like a boilerplate legal contract clause, meaning that it's just legal terminology that's pretty much the same from contract to contract. This is should be very specifically tailored to the common vision between the manager and the artist. So it's going to be very unique. And typically, what managers do to realize this unique vision will be to specify how they intend to develop a professional network, in what ways they're going to supervise brand development through either publicity, public relations, advertising, touring, working with agents to sell and develop merchandise, whether or not a record label or the sales of phono records or copies of recordings will be part of that plan. The management contract itself, outside of that one topic, appointment of authority, typically will address how long it's going to be good for, because of California law that does not recognize personal service contracts, and that's the kind of contract that a management contract is, for being, it's not enforceable for more than 7 years in California. That's become sort of an industry standard. And you see that typically 3, 4, 5, maybe 6 years is a really long contract, but that's going to be the term. And depending on who has the clout, there'll be options to get out of the deal. So a 1+1+1 structure would be a 3-year contract with an option to continue or get out at the end of each of those years. There are also sunset clauses or kick-out clauses that talk about getting what happens at the end of the contract. And power of attorney is an important concept I think we're going to get to in a little bit, but it basically gives the manager the ability to act in the place of the artist for hiring and firing, signing agreements, even signing and endorsing checks for deposit into the bank. An important concept here to keep track of is commission. So we talked about 10 or 15% as being the kind of rule of thumb or ballpark for the rate of compensation, but that's kind of a meaningless, or it has limited meaning if you don't get into, or if you don't address where that money is actually being drawn from. And so a manager who's making, say, 20% of revenues from touring may feel they're in a better position than a manager who's making 15%. But if that other manager is making 15% of not just touring, but also merchandising, artist royalties from sales of records or songwriting or different deals that they may have endorsements, now you're talking about a completely different deal where the 15% is actually way higher in net income than the 20% because the base is construed as being either very narrow for the 20% or wide for the 15%. Key man clause is an interesting idea in which an artist who signs with an agency, if the manager that agency assigns them leaves, then an artist with clout enough to get a key man clause can say, all right, I don't want to just be kicked to some other manager. I want to stick with this key individual. And if they leave, then I can get out of the contract. These are exclusive deals, but it's a one-way exclusivity, meaning that the artist, of course, can't have two managers, but the manager can have multiple artists. And so we're talking about, if it's 15%, you extrapolate that in terms of, how many artists will the manager deal with. 15% times roughly 7 would be a full roster because that gets out to 100% of income. If it's a part-time manager, they may have less than 7, but a manager with more than 7 clients, usually somebody's going to be suffering in that, and that can lead to some of the kinds of cases that you'll see in the court. All right, let's keep on moving here. So now let's move on to agents. You can see they come in a little bit under 10 to 15%. Their responsibilities are a lot more narrow, but just as crucial as the manager because they are in charge of getting employment for the talent, whether it is a musician or an actor. Actors will also have their own agents. So they're finding and receiving employment offers, and their contracts, the performance contracts or the contracts for at least on the musician side, will oftentimes be very specifically oriented towards the performance. So how long they're playing for, how many sets, the length of the engagement. And then at the end of the document, you find these various riders like, what's the security detail supposed to be? What kind of technical needs will the artist have in terms of perhaps backline, like instruments or drums or bass amplifiers that are already on stage? Excuse me. Or hospitality needs. So the hospitality riders are kind of the more famous ones because bands like to show how amazing they are by requesting very odd things. Okay, let's see if I can get this to continue. All right, California law. As I mentioned before, California does have a strict control over employment agencies or talent agencies. In the fact that they require registration of their agents alone is rather unique. They prohibit managers from acting as agents, and we also see this in New York law because they want to make sure that you don't have a conflict of interest taking place where the manager may be making employment decisions based on their own personal reasons as opposed to what's best for the artist, or that's also known as a fiduciary relationship. We'll get into that with the lawyers in a second here. It's true that all states regulate employment agencies. However, California and New York are leaders, as we've discussed a little bit, in terms of their regulation of managers. And they kind of set the template because they are entertainment industry centers for the way that management, artist management, is handled outside of those centers. So, and the way that management as an endeavor is construed. So, garage bands, local bands that have a friend managing them, the first thing that they do is start to set out and try to get work for the artists. However, the larger they get, the more this employment-seeking aspect is separated out from that job. It's illegal for managers to act as agents, in fact, in these two locations. Brief word about attorneys. Entertainment law is not a discipline or sub-discipline within the practice of law. Entertainment attorneys are simply, an entertainment attorney is simply becomes known as an entertainment attorney because of their experience working with certain types of clients. So that's just something to keep in mind. It's not a legal discipline per se. The way that they're paid may vary based on the needs of their clients. A client who just needs to get a contract drawn up or a license or a performance agreement or something, they may go for just the hourly rate, which is not a trial rate. Trial rates are much higher. Or if they are going through a period in their career where they feel like there's a lot of growth and they're going to need to retain services over maybe 3 to 5 or 6 months, they could pay a certain amount of thousands of dollars for that to retain the services. If, however, they're at even a higher level, they're always and they want to have an attorney on hand at all times, then they're also cutting them in at this manager's rate of 15 to 20% of their gross income. So what you find now is that artists at this high level, they may be making, and this is not even a very level 3 or very celebrity kind of example, but an artist that's making, say, $20,000 or $30,000 for headlining a festival, once you get in what this attorney commission rate is, along with the other two, the agent and the manager, that's approximately 15% or up to 50% of their take is gone. And so you can see that the pie gets diced up pretty quickly. In terms of the ethics of artist management, I talked a little bit about, or I mentioned fiduciary duty a second ago, which means, succinctly put, that the representative, whether it's a manager or an attorney in this case, is acting in the best interest of their client at all times. And so this is something that you'll see in some of the cases where artists and managers or the attorneys get involved, and they may argue that fiduciary duty was breached, or there was a breach of trust in the relationship. Another term you may see is unconscionable contracts, which means that the terms of an agreement are so bad, so slanted in favor of the corporate interest, whether it's a record company or a talent agency, or even a venue, that the contract is simply unconscionable. Nobody would agree to it. And sometimes in haste, artists who are not managed and don't have someone to translate the language will sign these contracts and then end up in court because they're really, really one-sided. A few words about music publishing here. Music publishing is basically a music publisher is an entity that presides over the copyright Circle C, which in the music business is the song itself. There it is right there. So the song as a composition has to be licensed out, by itself, it's just like a poem. It's a collection of words set to music, so you've got an arrangement of chord changes, melody line, and these lyrics. In and of itself, it's not going to make any money unless it's exploited. And so, music exploitation is another way to describe music publishing. So, their job is to get out into the marketplace and actually plug or place the music with other artists, record labels, um, television or film producers, even uh, video game producers also are in need of music, and so it's the publisher's job to get out there and do that. And you can see that over the last 100 plus 150 years, the kinds of technological developments that we've seen have actually given a lot of, have bolstered and boosted the avenues, increased the avenues of exploitation for these music publishers. Um, Through the first dramatic license, so getting like Broadway music on stage. Public performance license would be, a non-dramatic performance, so something that's dissociated from a play, all the way through motion pictures for synchronization, um, recording, so turning Circle C, the song, into the phono record, which is what the record company makes, like as a CD or an MP3. These are all the kind of interior licensing, interior agreements within the music industry that helps music get out into mass media. In terms of the value and how, so it's $11 billion distribution globally speaking. The distribution you can see is really favored towards the public performance sector here. So this is in red. And once again, public performance isn't just concert industry, which is pretty big by itself, but you're also talking about radio and broadcast, um, and television and the internet. So if it's a public media and it's broadcast, then it requires that clearance for, and that money gets kicked back to the publisher, who typically will split 50-50 with the songwriter, who's an owner. And the rest of these will change from year to year, but you can see that you've got mechanicals, for example. So these are the rights, the payments that record companies pay to the publisher to have the right to to perform the song in their recording studio and make that master copy, and then mass duplicate that copy onto CDs or MP3s. Types of music publishers, we've been through an era of consolidation, and so the major conglomerates have gained market share by buying up record labels as well as music publishers, as well as live event um, uh, production companies, like Live Nation, for example. And so that's a conglomerate. Now, the record companies that are consolidating within their own sort of sphere or sector of the music business, they typically will also open up their own publishing branch, meaning that it will allow them to not have to pay out. If they can secure publishing rights, then they're reducing their overhead because they don't have to pay out as much for the right to do what they do, which is getting those mechanicals. And then you've got independent, like standalone publishers that will either work to administer intellectual properties, administer songs, so the rights to songs. You find that these are oftentimes, oriented relative to a specific genre. So there are niche market publishers in that respect, and self-publishing artists like myself. I'm a songwriter and performer, and so I have my own catalog of songs. And I wouldn't say that it's worth a whole bunch, but if someone wants to use it, which they have, then I'll get a little kickback because I am an independent publisher as well. In terms of U.S. music publishers in 2016, here's the breakdown in terms of, you can see most of the publishing. So intellectual property, once again, is one of the main exports of the United States. You can see the value by group here. So Sony, which had the Beatles ATV music publishing here, but I think that deal just went through to Paul McCartney to recapture the Beatles catalog, was located there. Universal Music Group's publishing branch is called Universal Music Publishing. Warner Chappell, BMG, Cobalt is an independent here. So you can see that the kind of those are the main players, at least in the U.S. music publishing scene. It should be noted, however, that many of these are actually not U.S. owned. They're just their primary offices are based in the United States. BMG, I believe, is German. Universal is French owned, Sony Japanese owned, etc. Okay, so as we get a little bit more detail in terms of publishing, what I want you to know for sure is this slide here. So, and it is really not very. I think I must have changed the resolution on the screen, but in any case, this is the music pipeline, and I'll go back and show you, how to make sense of this. This is like a template, but you see that you've got various types of licenses that unite the owner. So you've got ownership on this side here. Who owns the song is going to be the songwriter and the publisher. There's a mechanical license here that is required for the user, which is the record company, to make their product and get it out to the consumer, which is the record buyer. Okay, so I've played that out. So this is the record kind of across here, and then down here you've got what the film producer or the television producer needs in order to secure music. So they're going to need a synchronization license to secure music to create their product to get into the movie theaters. Down here you see that the venue or the broadcaster will need the public performance license here to get their product out to the concert goer or radio listener, and the same thing for print music at the bottom. Okay, so it's kind of a grid you can see that has the owners, the license types. Oops, I don't want that. That's too bad. There we go. And the users, and then finally the consumers. So when we go back to the previous slide, let's see. You can see that I'm just showing you the type of music and who is actually paying the publisher. Okay, so the main things to recognize here is the PRO is performing rights organization, and so you see a predominance of PROs here that justifies and shows why the public performance right is so valuable and makes up that big piece of the pie graph, that 66% that we saw a couple slides back. Always remember that mechanicals go to the with the record company, sheet music sales go with the print music company, and that's going to have a lot of your of that chart filled out for you. Okay, so you'll probably see a chart like this in a test situation, so be ready for it. Right above here, just a little bit more detail on public performance. Since it makes up such a large slice of the pie. You've got these three entities, ASCAP, BMI, and CSAC, that are known as PROs, or Performing Rights Organizations, and they just stand between the publishers and all of the world's radio stations and concert venues, so that they can kind of simplify the process of these rights clearances, as opposed to every time a radio station wants to play a song, they don't have to look up who owns it. They just buy, quote, a blanket license, so that they have, between ASCAP, BMI, and CSAC, you're probably talking about, 17 million songs. And so when you've got that blanket license, you've just got access to the entire catalog, and you can play everything that's in the, quote, American Songbook. So what these guys are going to do is it will be to issue licenses. A blanket license is what I just talked about. They'll track the public performance on radio or at the venues, and then they'll collect money from the users, the venues, or the broadcast companies, and then redistribute that to the publishers and songwriters and composers. So they are an interesting kind of, they occupy an interesting place in the music business. Trademark. Okay, just a couple things on trademark. It's an important aspect in branding, and so it's something that the artist manager will be eager to develop or to work on early in the career. And it's something that the more established artists will recognize a great amount of value in their trademark. So what we're talking about are logos that allow for products and services that are traded and commodified and sold over state lines need to have a federally registered trademark to kind of differentiate themselves from other similar products and services. So the Lanham Act is the source of our current trademark law, and it was originally part of the old Interstate Commerce Commission. It was their jurisdiction, but the Interstate Commerce Commission folded, and now the federal trademark renewal is for every 5 years. If you want a state trademark within Indiana, you're talking about a 5-year renewal period. And if you do nothing with it and you're not using it, then after 10 years, it's considered to be abandoned and can be picked up by somebody else, by another company. So here are some examples of trademarks, these bottom 3 down here. So as I mentioned, it's going to protect there's a dual sort of philosophy behind what it's protecting. It's protecting the brand name and value from the owner's point of view, and it protects consumers from confusion so that they know they're associating a certain amount of quality or a certain experience with a given brand. The trademark will sort of works to certify that in their mind and reinforce that. What's actually protected? Words, phrases, symbols, and sounds. So McDonald's, I'm loving it. Nike swoosh symbol is just the symbol. And so those are trademarkable. In terms of when you get into a dispute, or as far as the law is concerned about trademark protection, it does recognize various levels of strength. And so if you're talking about something that has a very weak level of protection, that would be like a generic bottle of aspirin that just says aspirin on it, and there's no artwork that goes along with it. So that's basically impossible to protect. But when you get up here and you've got like these arbitrary, suggestive, or fanciful, more artistic and creative types of trademarks, that's a lot easier to protect. And then you've got this middle group, the descriptive trademarks, Tinder Vittles, or Internet Marketing Group, kind of a little bit in between in that it's describing what it is that it is, but not all the time in a very innovative and unique way. So the more unique and innovative, the stronger the strength of the trademark protection. So that's it, folks. Thank you so much for joining me. I hope that you've enjoyed the class, and I look forward to seeing your final projects. As always, don't hesitate to reach out and let me know if there's anything I can help you with. All right, take care.